My name is Scott Reich, and this is Crime Talk. Yes, you have found the weekly recap of the week's top stories here on Crime Talk, all located in one convenient location. Hope you enjoy it. Have a wonderful day. We'll see you next time on Crime Talk. Well, the new judge in the Delphi matter is sticking to the schedule. Now, court proceedings related to the Delphi murders of Abby Williams and Libby German will remain in Carroll County. Now, the Allen Superior Judge, Fran Gull, has already started her work on the case, apparently, and she was appointed to handle the proceedings after Carroll County Circuit Judge Benjamin Diner recused himself. The Indiana Department of Corrections released photos of Richard Allen, the man obviously charged in connection with the Delphi murders. Now, Diner's cited concerns about his personal safety as well as the flood of media and public inquiries about the Delphi case. And I get that. If the judge truly feels he can't be fair, he's got to do what he's got to do, which is to withdraw or to recuse himself. I'm just a little surprised that a judge would be so intimidated by something that hasn't taken place. If they treat this like any other case, what would it be? Why would somebody threaten the judge? The judge is going to follow the law, right? Just weird to me. I've seen some reports, but I can't confirm it, that his wife knew somebody that was related. I don't know. It just seems like if you're the judge, this is the biggest case that's probably happened in Indiana in many, many years. You think you'd want to be in the game. Kind of the old, give me the ball, coach, put me in, that kind of stuff. But no, apparently this guy got a little scared. I'm not judging. He's got to do what he's got to do. No one's going to. No. Usually, remember, ladies and gentlemen, when somebody leaves the courtroom, no matter what kind of proceeding, somebody is usually unhappy, and they're usually unhappy with the judge. So I just don't see why this case is any different than anything else that would become before this judge's docket. So the matter for Mr. Hall was set on November 22nd to determine if the sealed court records pertaining to the arrest charging Mr. Allen will remain out of the public eye. Now, they should be released. I know the prosecution and the police don't want them released because it may show several years of ineptness. It really could. And if the police have something overwhelming, we should know. Now, hopefully, since the public defender, or at least was requested by Mr. Allen, hopefully they've at least been appointed, that they've reviewed the affidavit with him as well. But as of right now, it would appear that he may not even have access to that as well. So hopefully the information is out there. One of the things that's different from courts here in the United States and in other parts of the world is that, well, things are kept secret in other parts of the world, not here in the United States. Yes, we're not going to get all the discovery, but the affidavit is a good roadmap for the American people to see what is taking place. It's not the whole picture. I get that. But the defendant has just as much right to see what he's being charged with and what evidence he has against him. And frankly, so does the public. So we shall see. Anyway, well, Judge Gull is sticking with the November 22nd date for the hearing. This has been confirmed by the Allen Superior Court clerk. And so hopefully this matter will be resolved sooner rather than later. And why is that significant? Because a lot of judges could have said, hey, we're going to do it in private. Or they could have said, we're going to continue this until after the holidays to give everybody a little bit of time. So I think it's important that the court is moving forward. I have a lot of hope for this Judge Gull. We did a show last week about her background, her time on the bench. I think she's going to be a good judge, and I think she's going to hopefully hold the prosecution's feet to the fire and say, we're unsealing this affidavit. Now, for those of you who do not know, on October 31st, the Indiana State Police announced the arrest of Mr. Allen, charged him with 2 counts of homicide in connection with the Delphi case. He's been moved twice for his personal safety and is currently at an undisclosed Department of Correction facility. And as I stated, police have not revealed how Allen is connected to the Delphi case or the potential role in the girl's death because, well, everything's been sealed. We'll continue to follow this case. Hopefully we'll have some new developments, and hopefully we will have some information soon as to what the connection is with Mr. Allen. Or maybe there isn't one. Maybe they're trying to do something. The police are trying to do something and try to figure it out now. I don't know. We'll have to wait and see. Well, Richard Allen of Indiana, who wrote a desperate letter to the judge earlier this month begging for help from a public defender. He said, quote, "I'm begging to be provided with legal assistance in a public defender or whatever help is available." Mr. Allen wrote in a letter to the court at his initial appearance on October 28th. Mr. Allen asked to find representation that he would pay for himself. However, at the time, he had no clue how expensive it would be just to talk to someone, not to mention hire somebody on a double homicide case. Well, the court has appointed Andrew Joseph Baldwin of Baldwin, Perry, and Camish, and Bradley Rozzi of Rozzi, Hillis, Rozzi, and Dean to represent Mr. Allen. Now, for those of you who don't know, Mr. Allen has been accused of killing Liberty German and her friend Abby Williams, on February 13th of 2017, after their bodies were found abandoned near a recreational trail. Now, the attorney with a little more experience, Andrew Baldwin, he looks like a, by God, no doubt gunfighter. He's been doing criminal defense for nearly 30 years. Bradley Rozzi has done litigation for 20 years. He has experience in criminal defense and is death penalty qualified there in Indiana. So Mr. Allen did well in his decision, probably the best decision that he's made thus far, other than keeping his mouth shut. He gets 2 private counsel at public defender prices. He's entitled to defense counsel if he cannot afford one, and he is indigent. Whether he had $100 or $100 million if he's in custody, he qualifies for a free attorney. In this particular case, Mr. Andrew Baldwin, he graduated from the Akron School of Law back in 1994. He graduated top of his class. He's a member of the National Board of Trial Advocacy and a criminal trial specialist. Some states have specialties that people can kind of qualify for. Some states do not. He's a member of the Indiana State Bar, the Hamilton County Bar Association, the Johnson County Bar Association. He's in fact been the past president. He's admitted to courts in Indiana, as well as the United States District Court for the Northern and Southern Districts of Indiana. Mr. Baldwin definitely looks like the real deal. Bradley Rozzi as well, graduated from law school back in 2001, admitted to the bar in 2002, and looks like he does quite a bit of criminal law, a little bit of divorce, a little bit of custody. You know, when you're in smaller towns, sometimes you got to take what comes through the door. But most of his cases appear to be that of criminal cases where he's done murder trials, attempted murder, burglary, child molestation, and drug offenses. And he has also represented clients accused of committing multiple murders and other heinous acts, and is death penalty qualified, as I noted before. Now, the judge, the Honorable Judge Gull, in this particular case, is the one that would have made the appointments, as I understand it, in Indiana. So I already had a good feeling about this judge. She's going to make sure Mr. Hall gets a fair trial, going to make sure that he gets competent counsel, and that's a good thing, all right? Certainly, if he's innocent, nobody wants an innocent man to go to prison for a crime they didn't do. Obviously, if he's guilty, he's entitled to due process before any punishment is to be imposed. All right. So we are going to have to wait and see. We got that hearing next week. Hopefully the affidavit will be released. I'm sure the attorneys are going to want to keep it quiet. But once again, some people think I'm wrong. Other people think I'm right. I think the public's entitled to know what evidence they have against Mr. Allen. After all, it's been 6 years, and the police have been very tight-lipped, and they've gone down a couple of roads that didn't exactly turn out to be correct. I'm sure something that Mr. Rozzi and Mr. Baldwin will certainly explore in their defense of Mr. Allen.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
So Judge Boyce has issued an order in the Lori Vallow matter, and guess what? She's competent. Let's take a look at what the order says. The order says, on this date, the court issued its sealed findings of fact, memorandum, and order subsequent to a competency hearing conducted on November 9th of 2022. The court has now determined that the defendant, Lori Noreen Vallow Daybell, is competent and therefore fit to proceed to trial. Therefore, the October 6, 2022 order staying the case is hereby lifted, and the court will reschedule trial in this case. Now, Lori Vallow's competency to stand trial was in question during earlier proceedings in May of 2021. However, restorative treatment was rendered, and eventually Lori Vallow was adjudicated competent to face the charges against her on April of 2022. But the commensurate order from that month was just as unilluminating as the one issued just the other day. Well, the renewed question about her competency in early October came shortly after concerns that Vallow was caught repeatedly smiling into the television pool's camera during a television hearing. Now, Judge Boyce has banned television coverage of future hearings because he believed that Vallow's Sixth Amendment rights were in jeopardy due to the highly saturated local and national coverage of this case. Now, Vallow's attorneys requested the clampdown on the coverage back on August 30th of this year, and prosecutors agreed with the defense on September 12th, and cameras were subsequently banned. The judge noted that there was no indication that any media organization had ever violated this previous order in the Vallow or Daybell cases. However, he was going to do it to protect the entire situation. In banning these cameras from future hearings, Judge Boyce went on at length to clarify that the issue was with the potential effects of the coverage and not with the actual conduct of the press in the court. All I have to say is, let's go do this thing. She's competent. Let's get a trial date, and nobody's moving on any dates. First, the judge has issued an order in the Chad Daybell case, specifically regarding the motion for sever that was argued about a week and a half ago, and the court says denied. Now, I think that this is worth reading almost in its entirety, simply for the fact that I think the court got it right sometimes and didn't get it right the other time. I think it's going to be a huge mess. I understand John Pryor making this motion, supplementing it, and there's still relief. But I think the judge feels confident that he is not going to be overturned on appeal if there is a conviction, but we will have to wait and see. So let's get to it. First, the court said that they are issuing the order pending. The court says that they're issuing a memorandum decision and order in regards to the motion pending before the court, specifically the motion to sever from the death noticed co-defendant in order to enforce Mr. Daybell's rights. The court notes, kind of, and this is what we talk about, the legal writing aspect. Here's the facts. Here's the background. On May 24th, the Fremont County Grand Jury returned an indictment against Chad Guy Daybell, Lori Noreen Vallow Daybell, and Alex Cox, who's now deceased, as co-conspirators in the commission of several crimes, including but not limited to multiple counts of first-degree murder and conspiracy. On June 9th of 2021, Daybell was arraigned on the charges listed in the indictment. On August 5th, the state of Idaho filed a notice to seek the death penalty. This court ordered that both Daybell and alleged co-conspirator Lori Noreen Vallow were to be tried together in a single trial, finding that joinder of the defendants was proper under the Idaho Criminal Rule 8b. Then on September 7th, 2021, Daybell filed a motion for severance, contending that severance was required to afford Daybell a fair and impartial trial, and supplemented the motion with a memorandum filed February 9th. On March 21st, 2022, the court issued a memorandum decision denying defendant's motion for severance. Then, on September 27th, 2022, Daybell filed a second motion for severance, and it was a 30-page memorandum in support of that motion. The state filed their objections, and there was a hearing on November 10th of 2022. In the interim, obviously, Mr. Daybell also filed to continue the jury trial, and that was granted. The court goes on in regards to the standard of review. This is the IRAC that we talk about in legal writing. You got the facts, which is, what's taken place before, the procedural background, what's the legal standard. Here we are, rule. Actions properly joined under Idaho Code Rule 8B may be severed under Idaho Criminal Rule 14 if it appears that a joint trial would be prejudicial. The criminal defendant bears the burden to show prejudice in making a motion for severance, and such motions are committed to the sound discretion of the court, and that an appellate court will review a trial court's decision on a motion for severance under an abuse of discretion standard, which means the appellate courts give great deference to the trial court making these rulings. But of course, if the appellate courts think the trial court got it wrong, they'll say that it was an abuse of discretion. So let's take a look at it. Now, under the motion filed by Daybell, he enumerated several sections of both the Idaho and federal constitution as additional grounds to obtain severance, specifically the heightened reliability required in capital cases. Second, a joint trial materially prejudices Daybell, and precedent exists to sever cases subject to the death penalty, and judicial economy, and Daybell's need for additional time to prepare his defense. The state obviously opposed that, saying that the defendant in his companion cases were properly joined, that the Idaho Criminal Rule 14 requires the movement to establish prejudice, and that Daybell has failed to meet that standard. The court then notes that Daybell has now twice petitioned the court for an order requiring the state to deliver the court all statements the defendant intends to introduce at trial. In doing so, Daybell puts the proverbial cart before the legal horse. Twice now in open court, the state has asserted it has delivered to Daybell every statement of the defendants in possession. The court is satisfied the state has complied with its duty to disclose to the defense the statements that may be introduced at trial. There's been no motion to compel related to an accusation that its state has failed to produce such discovery to the defense. Now, the rule expressly provides that the court may enter an order requiring the prosecution to deliver to the court for inspection in camera any statements or confessions made by the defendants that the state intends to introduce at trial. However, it is not incumbent upon the court before trial to parse through all statements disclosed in discovery in an effort to surmise the state's defendant's theory of the case, then determine upon its own investigation whether Idaho Rule 14 is implicated. While the defense has made general references to statements, there's been no reference to the content of such statements either in briefing or argument for the court to consider. Accordingly, the court again has been provided no basis to justify the issuance of an order for an in-camera inspection. Well, this is what we talked about before. Normally in a conspiracy case, the prosecution has to prove that there was in fact a conspiracy. They have to do that before statements come in of co-defendants that are co-conspirators, because otherwise then they're just hearsay. Normally that comes through either a proffer or before those statements are actually admitted as co-conspirator statements, the court has to make a determination outside the presence of the jury that the prosecution has in fact established a conspiracy. They don't get to just come in automatically just because they're charged as a conspiracy. I've had trials where people have been charged with a conspiracy and they've been found not guilty, which means they weren't part of the conspiracy. So maybe the court is putting the proverbial cart before the legal horse there himself. Anyway, we continue. Counsel for Daybell has argued that he is unable to articulate the content of any statements at issue because of an existing protective order limiting the dissemination of the discovery in this case. As you may recall, the court has imposed some sort of gag order that basically no facts can be discussed in open court for the rest of the world to see. And the court says, well, I'm not persuaded by that that these statements can be proffered to the court without running afoul of this protection order, and the defense is permitted to submit statements for in-camera review or file a motion under seal as set forth under the Idaho Procedural Rule 32 to avoid such concerns. However, that's not been done, and instead the court agrees with the rationale employed by the Supreme Court in denying severance in a case called State v. Fox. And it says, while we do not believe that Fox's attorneys needed to reveal his case strategy in open court, Fox needed to provide something more to the district court to establish prejudice than his bare assertion that joining the charges would confound his defense. The court then says, hey, you have to show prejudice. Prejudice is damage or detriment to one's legal rights or claims. The court then goes through and says that the prejudice that Chad Daybell is citing as one that's depriving him of presenting a complete defense by creating a conflict between a Fifth Amendment right against self-incrimination and the right to an individualized sentencing determination, by creating a conflict between the alleged co-conspirators' respective constitutional rights, including the rights under the Confrontation Clause, by frustrating a consideration of mitigating factors in the debate in the Daybell case, and by impinging upon due process and the right to withhold the penalty phase evidence until the appropriate time, and by creating an inherent risk of gender stereotyping that could taint Daybell's right to an individualized sentencing. The court then goes on and says, hey, for the reasons cited above, the court finds that the pending conspiracy charges keeping the alleged co-conspirators who have been properly joined for trial is favored and appropriate without necessarily impinging upon any alleged co-conspirators' right to a fair trial. It stands to reason for exactly the reason Daybell raises, the need to introduce certain statements of alleged co-conspirators to mitigate accusations raised against Daybell. A joint trial is favored. Antagonism between defenses or desire of one defendant to exculpate himself by inculpating a co-defendant is insufficient. That means pointing the finger at each other. So this is going to get really interesting. And when we talk about antagonistic defenses, pointing the finger at somebody saying, I had nothing to do with it, they did it all, that's going to be very interesting at trial. And a lot of the evidence that Mr. Pryor may want to come in regards to everything that Lori Vallow allegedly did with her brother Alex Cox in Arizona, Lori Vallow is not going to want that to come in to kind of set the stage that she's a bad person. That is 404B evidence. And what we've seen, we've received from the public, I guess, no notice of the defense requesting 404B evidence, no notice of what the prosecution intends to introduce as 404B evidence. Remember, the defendants have a right, Lori Vallow has a right to be charged on these charges and these charges alone. And so to bring in other evidence to show that she acted in conformity therewith because she's a bad person from these other charges where she has not been found guilty, do you think Mr. Archibald is going to let that come in or want that to come in for Lori Vallow? I don't think so, but John Pryor does. So we may be getting into a little more than just a conflict here of defenses. We've got some evidentiary issues that are going to be super hard for this judge to figure out. And the court basically says, well, we can give a limiting instruction. You can consider this evidence for this purpose as to this defendant, but not to this defendant. But that bell has already been rung before the jury. It's going to be a mess. I get the judge wants to keep these cases together. I get it. From a legal perspective, I'm telling you, these cases should be severed. Go try these cases twice. Give everybody their full opportunity for a fair hearing and then render the verdicts. But to kind of jam it down the throats of everybody saying you're going to get this and let the evidence come and be damned, I'm telling you, this is going to be a circus. And the judge has just created a circus by stating that he is going to have a joint trial. The court goes on stating that next Daybell says that this argument that a joint trial runs afoul of Bruton, which is the United States Supreme Court case, where the Supreme Court said if you're going to point the finger and statements are going to be introduced as to one defendant, is basically a confession, and not something as it relates to the other co-defendant, you have to sever. And so the court says the protection for a defendant from out-of-court statements and a co-defendant in a joint trial where the co-defendant does not testify. As is typical at this stage of the case, it is unknown if either Daybell or Vallow will elect to testify. While that possibility remains, all parties agreed at the hearing that the motion that they are unaware of any pretrial confessions by any defendant or co-conspirator. The state affirmed to the court that there is no Bruton issue at the time and offered an alternative solution to severance should Bruton become germane to these cases. For example, they went dual juries. While that issue is not right before the court and the court makes no advisory opinion on the issue, the court is persuaded that Bruton is not appropriately invoked to justify severing Daybell trial from Daybell's trial at this juncture because there's simply no evidence that any incriminating statement will come in. Bruton was a confession. Incriminating statements can come in various different forms. Anything somebody says can and will be used against them. So I think the court is taking a very simplistic ruling here, but part of that also comes down to Mr. Pryor not providing sufficient and ample information as to what he thinks, what statements are not admissible as to his client, but maybe admissible as to Lori Vallow. So maybe between now and a trial date that is yet to be determined, Mr. Pryor will come up with yet a third motion. But basically the court says, denied, we're going to trial. And based upon the ruling just a couple of days ago, Lori Vallow is apparently competent. So apparently those issues are resolved. Somewhat to my surprise, I'm not going to lie, I thought she was down for the count. So let's get all the parties into court. Let's set a court date. Let's set some deadlines for all motions to be filed by both sides. Set a block, maybe a week for hearing. Have those issues resolved months in advance of the trial date so this matter can proceed on the next scheduled trial date. And if Mr. Pryor is not going to be able to get co-counsel or stay on the case, he better get off now. It's always interesting in Idaho.